Welcome again to the last episode of this series of Wealth Plan TV. I hope you've enjoyed it. We've got Scott Amberley from Legal Essentials with us again to talk about estate planning. Thank you for coming and joining us again, Scott.
Not a problem.
We thought about the first episode and we spoke about enduring powers of attorney and how if you didn't have an enduring power you could apply to the court. Before we start this about the mistakes of the rich and famous, Scott, can you very quickly tell us the costs associated with each outcome, writing your own and applying to the court?
Well, writing your own, the costs vary according to whichever lawyers or whatever charge you to get them done. But to get them done when you've got a capacity is really quite easy to do. Get them done to apply to VCAT, the Victorian Civil Administration Tribunal, to apply for a financial power of attorney. We charge $5,000 to do that application.
So do them. Today we're talking about the mistakes of the rich and famous. Scott, a recent mistake of a rich and famous was Peter Brock.
Yeah, Peter Brock.
Can you tell us a bit about him?
He died in 2006, car accident, which was unfortunate for him. But his cavalier, as he's described it, his cavalier attitude to getting a will done, I'm not going to be here, so what does it really matter? And he did a couple of different legal will kits and one done by lawyers. So what ended up is the one that was done in 1984 was done with lawyers, and it went all the way back to that one and ignored the ones he'd essentially done with the legal will kits.
So Peter Brock ended up with 3 wills. Can you tell us about the 3 wills?
Yes, well, he had one done prepared by lawyers, and in that one, it was done in 1984, and that was the one that ended up being the one that was granted probate. He did another 2 more, one which his assistant typed up on the computer, but he got distracted by a phone call and never signed it. And then there was another one, and there was problems with that one as well, and that ended up not being granted probate either. So it went all the way back to done in 1984 with lawyers. And that's created the precedent that says, if I do a will with lawyers, so if I came in and do a will with Legal Essentials and got your will done, and at some point in time you go, oh, you know what, that was too hard, I'm going to go do another one somewhere else, or sorry, not with another lawyer, but I'm going to do another 30-year legal will kit, and you make some serious errors of judgment on that, and it wasn't witnessed properly, it wasn't signed properly, then...
Or not even signed at all in this case.
Or not even signed at all in this case. Then the court would just ignore it and do the one done by lawyers.
So is this the Brock precedent?
Yeah, he's created a precedent after he's died. So.
Yeah, so he's not only a famous racing driver with many accolades, he's now a legal precedent.
He's now a legal precedent, that's correct.
Something that the viewers might be aware is the first clause of a will renounces all previous wills.
That's
so
correct.
This precedent is quite groundbreaking, I guess.
Yeah, the first thing a will does, signing a new will, is revoke all previous wills you've done. And that stands for even all the legal will kits.
I heard a story about a man who wrote a will, signed it, kept it in his pocket with the intention of when he was going to die he'd just fill in the rest. Because he had a couple of mistresses and he couldn't decide who was going to get the money. This was the story. He was hit by a flaming oil truck and didn't have the opportunity to do that. And because he had a will in his pocket which revoked all previous wills, he actually was viewed to have died intestate.
Yep.
It's interesting how these things work, isn't it?
Well, there's one that was put through the Supreme Court where the lady wrote, there was a telephone on the wall, and she wrote just below the telephone on the wall where she wanted everything to go. And that still counted as her will. That was signed, dated. Wasn't witnessed, but that was signed and dated, and that was actually counted as a will. So they had to take the piece of the wall out of her house. So there was an extraordinary amount of money to come and take the will out of her house. So it ended up costing her a heck of a lot more if she'd just done it properly with a lawyer. So, you know.
The only time I've heard of people cutting walls down is for Banksy's. Tell us exactly what happened to the Brock estate. We've seen what he's done prior to his death that's caused problems, but how did that actually pan out for the parties involved? In terms of expense and in terms of maybe outcomes which Peter Brock mightn't have actually desired.
Well, the legal fees were about $250,000.
And what was the estate worth, do you know?
A lot more than that, but still,
Fortunately,
you wouldn't argue over it unless it was worth a substantial amount to argue over. Although I've heard a good story about three brothers who argued over Dad's $3,000 chainsaw because all three of them were promised it, and then all of a sudden all three wanted it, and they ended up spending about $10,000 worth of lawyer fees. So really, the winner can be lawyers, and the same with the Richard Pratt's estate. We've had now the case of the lady applying in the New South Wales Supreme Court, and she wasn't just, any will can be challenged.
yes.
And wills need to be able to be challenged. There's sometimes unfairness in the will that needs to be able to be challenged. But now if you want to challenge, and you're I think the vexatious litigant, so you're just applying because you think you've got a case when you actually don't, you may end up with more fees than you think. And this lady ended up with $50,000 worth of lawyer fees from her lawyers,
Yep.
and $50,000 from Richard Pratt's estate. So she ended up with a $100,000 bill that she has to pay in lawyer fees because the court went, you don't have a case. So while anybody can challenge a will, you really need to have a case.
As you can see from our conversation, even the rich and famous get it wrong. If you want the outcomes that you desire to occur on death or incapacity, you actually have to take the care to make sure that that happens for you and the people that you care for. Thank you very much. We'll see you after the break.